distinguished panel consists of President Reed and the Honorable Judges Goldstone and Crane.
Thank you. Please be seated.
As you're all well aware at this point, the case before the court is the matter of the Republic of Adova versus the state of Rotania. The applicant and respondent teams are each allocated 45 minutes to present their respective pleadings, and good luck to those sides.
Thank you. Good afternoon, counsel. May I invite the first agent for Adova to step to the podium? Please proceed.
Thank you. May it please the court. My name is Margot Day, and along with my co-agent, Mr. Alex Layton, we represent the Republic of Adova, the applicant in the present case. I will be presenting for 21 minutes. My co-agent will also be presenting for 21 minutes, and we would like to reserve 3 minutes for rebuttal. We are here today because Rotania sent its military into our borders, abducted 12 of our citizens, brought them to Camp Indigo where they were severely mistreated, and are now holding them illegally before the Rotania Military Tribunal. Because of this, Adova respectfully requests this court today to declare that Rotania violated international law, to order the repatriation of our citizens, and to award compensatory damages. There are 4 main issues in the present case. The first issue is that Rotania violated Adova's territorial integrity when it sent its military into our borders and abducted 12 of our citizens. The second issue is that Rotania violated the Convention Against Torture and the International Covenant on Civil and Political Rights when it severely mistreated the 12 Adovan abductees. The third issue is that Rotania cannot hide behind the principle of malacaptus benedictentis in order to justify an unfair trial. And the final issue is that in order to pursue justice, Adova was correct in exercising its jurisdiction over former President Kurgov and Professor Venitza. I will discuss the first 2, and then my co-agent will discuss the latter 2 issues.
Madam, aren't you kind of coming to us with unclean hands here? The facts seem to show that Adova has some relationship with ILSA. What's going on here?
No, Your Excellency, we do not come to this court with unclean hands because, in fact, Adova is not responsible for Laps's criminal actions. Now, Rotania might try to submit today that they could justify their breach of territorial sovereignty under self-defense, but in fact, one of the very reasons they cannot rely on self-defense is that Adova is not responsible for Laps's actions. Your Excellency might be referring to paragraph 7 of the compromis, in which it shows that there were financial ties between Adova and Laps through 2004. However, there are no records available after 2004, so when Laps turned to violent measures, there is no evidence that Adova and Laps were even in a financial relationship.
What does the unclean hands doctrine mean? What is it?
The unclean hands doctrine, Your Excellency, is if that one party contributed to a wrong, it cannot then benefit from that wrong. And so in this case, however, Adova has committed no international wrong in the first place, and so in this case, we could prevail on this claim.
And if they had, Ms. Day, is there a question of proportionality, or was it an absolute bar?
Your Excellency, there still would be a question of proportionality, and because it can just be a mere factor taken into consideration, but it doesn't always have to be a mere bar to any remedy. Now, if we look to the doctrine...
A related question, Ms. Day. You're well aware that we are an entity of the United Nations, and as I understand the compromis, your government did not comply with a Security Council resolution that had to do with your giving sanctuary to Ms. Penza and others. So could you please connect that to the unclean hands?
Of course, Your Excellency. In fact, the very reason why we could not conduct that diligent search that Security Council Resolution 2233 asked us to do is that before that 15 days was up, Rotania had already come into our borders and abducted our citizens. The reason I say this is that according to paragraph 31 of the compromis, on April 3rd, Colonel Venitza specifically said that he took the Adovan citizens, quote, several weeks ago. Counting back several weeks, even giving it the most conservative reading possible, 2 weeks, that would put it before March 22nd, which was the deadline that the Security Council resolution gave. So in fact, we had no way of fulfilling this obligation because Rotania had already taken matters into its own hands, come into our borders, and abducted our citizens.
Well, that's a good factual answer, but as I recall, your government announced that it would not comply with the Security Council resolution.
Very true.
What is the significance for that in international law?
That's very true, Your Excellency. In Appendix 2 of the compromise, our Prime Minister did indeed state that certifying that search would be a violation of our sovereignty, and instead suggested, what of course we suggest today, that these people should be tried within our own courts and our own borders. Now, Adova submits that even if this court finds that that's an anticipatory breach in this case, an anticipatory breach or a breach of a Security Council in general does not warrant one other country unilaterally enforcing that Security Council resolution. I point this court to Security Council Resolution 1441, and after Iraq violated that Security Council resolution, the United States decided to unilaterally enforce that. That action now has been roundly condemned by the international community because the general recourse for a violation of Security Council resolutions, which quite unfortunately happen fairly frequently, is that the parties go back to the Security Council reconvenes, issues further condemnations, then turns to economic sanctions, and then finally turns to use of force. We see this exact progression regarding the Democratic Republic of the Congo when it continually violated arms trade embargoes that were put on them by the Security Council.
Aren't you, in fact, supporting terrorism in Rotania?
Adova submits we are not, Your Excellency, and that for two reasons.
What is the state of the law on state responsibility towards supporting terrorism?
The state of the law, Your Excellency, looking to Security Council resolutions, for example, 1373 or 1566, or looking to the conventions on the financing of the suppression of terrorism, do indeed state that states do have a due diligence requirement to prevent terrorism and to not finance terrorists. However, in this case, Adova first of all submits that this due diligence test is the incorrect test for this court to apply, and rather it should look to the effective control test. But even if this court did apply that due diligence standard, Adova has not violated it because the lapsed organization is not a terrorist organization.
So does that mean that that is the position of your case and your government, that the right to self-determination, it trumps terrorist concerns?
In fact, you know, Your Excellency, a self-determination movement, although that right's enshrined in the International Covenant on Civil and Political Rights or the International Covenant on Economic, Social, and Cultural Rights, it does not allow a self-determination movement to act with impunity. And if that self-determination movement does violate international law or commit terrorism, it of course can be held responsible. But today, Adova is now espousing claims on behalf of LAPS as a self-determination movement. In fact, we roundly condemn what LAPS did, and that the burning of 4 buildings and the killing of 22 people is terrible. But in fact, what Adova here today is stating is that we are simply not responsible for those actions. Now, when this court looks to state responsibility, it continuously applies what's called the effective control test to determine whether or not a state is responsible for the actions of non-state actors. This court first outlined that test in the 1986 Nicaragua decision, where it stated that, and I quote, mere financing, supplying, and equipping a non-state actor is not enough to make a state actually legally responsible for that non-state actor.
And what about giving sanctuary to terrorists?
Your Excellency, if indeed this court finds that what LAPS did and that it is a terrorist organization, and even if this court finds that Adova's violated its due diligence requirements in regards to terrorism, the recourse is not a violation of our territorial sovereignty. This is because, according to this court's holding in the Iran hostages case, this court found that Iran did indeed violate its due diligence requirements regarding the hostages that were kept in Tehran. However, when the United States decided to respond by sending a helicopter into Iran, this court roundly condemned that in paragraphs 194 and 195 of its decision, saying that a violation of due diligence does not mean that one's country then must be violated in return. In fact, the United States State Department has found that there are 136 countries that have known international terrorists within their borders. If this court holds that just having a terrorist within one's borders allows its sovereignty to be breached, I certainly wouldn't want to live in those 136 countries that now could have their territory violated. But if we turn back to a moment to the effective control test, which this court again reaffirmed just last year in 2007 in the crime of genocide case, this court found that even though there were financial ties between Serbia and Bosnian Serbs within Serbia that did not make Serbia actually responsible as a state for the crimes against humanity that those Bosnian Serbs had committed. And therefore, Adova suggests that in this case, under the effective control test, we are not responsible for the criminal actions of lapse. Now, the second reason why Rotania cannot rely on self-defense is that they simply did not follow Article 51's requirement to notify the President of the Security Council.
But how can that, I have a problem with that argument, because the act of self-defense, by definition, must precede the notice.
Your Excellency.
And surely one tests the legality of the self-defense on its merits and not, I don't see how one can negate the right to self-defense, as it were, ex post facto, because of lack of compliance with what is really a technical requirement.
Yes, Your Excellency. The answer to your question is, in fact, twofold, in that although the right of self-defense is inherent, when countries decide to be members of the United Nations and sign on to the UN Charter, they've essentially restricted that right themselves, and that they are now bound by Article 51, which does require that notice. And the second response is this is not mere form over substance. There is a very important purpose to this notification requirement, in that it establishes a legal record for the rest of the international community, namely the Security Council, to look at to determine whether or not that actor acted proportionately and out of necessity. Without that legal record, it's impossible to know if these actions, if a state's actions would be proportional, would be necessary, or comply with the other customary international law obligations.
But what would the notice have told the Security Council that it didn't know from watching CNN?
And also after they'd already issued a resolution affirming right to self-defense.
Right, Your Excellency. First, showing what they could have shown that maybe they wouldn't have already known. I point this court to the Democratic Republic of the Congo, versus Uganda. In that case, Uganda decided to use self-defense, but because it never notified the Security Council, even though the Security Council was well aware of what was going on and that it had issued no less than 31 Security Council resolutions about that subject, even though they knew, the International Court of Justice still found that because Uganda did not go through that requirement, it could not rely on the doctrine of self-defense. And turning to Security Council Resolution 2233 that the President just asked about, a reaffirmation of self-defense before the action is taken does not necessitate that that action ends up being legal, and that a reaffirmation of self-defense is not a blank check that allows a country to use force in any way it deems fit. It still must be able to attribute the original international wrong to a state. It still must act out of necessity and out of proportionality. It still must be responding to an armed attack, and it still must go through that procedural requirement.
What is your understanding of proportional when you're dealing with self-defense and the self-defense doctrine?
Your Excellency, of course, proportionality doesn't have to be exactly tit for tat, and that just because 22 people died, it doesn't have to be exactly responsive on the other side. And in fact, in this case, in the spirit of reasonableness, Adova will concede that what Rotania did was proportional, but the reason that they cannot rely on self-defense truly turns on that attribution requirement. If it pleases the court, I shall now move on to the second issue. Thank you. Rotania violated the International Covenant on Civil and Political Rights and the Convention Against Torture when it severely mistreated the Adovan abductees at Camp Indigo. According to paragraph 33 of the compromise, our citizens were subjected to hanging by the wrist from chains, inadequate food and water. They were stripped and kept partially nude for a several-week-long incommunicado detention, and they were sleep-deprived through the use of bright lights, discordant music, and loud music. And Adova does indeed contend that these are acts of torture.
Well, what do you mean by torture? What is the definition of torture?
The definition of torture, which is outlined in the Convention Against Torture, is severe pain and suffering inflicted by a public official on somebody for the purposes of gaining information. Now, admittedly, Your Excellencies, this is a rather vague definition, and so Adova points this court to other bodies, to other regional courts that have interpreted this definition and found that indeed the acts that have occurred here are torture. First, to the Human Rights Committee in Mukong v. Cameroon, a 1991 case. In that case, Mukong was held for 2 weeks incommunicado and provided with inadequate food and water, and he sustained no permanent injuries. but nevertheless, the Human Rights Committee found that in that case, torture had indeed occurred. If we look to the European Court of Human Rights, in Aksoy v. Turkey and Verlap v. Turkey, we find that hanging by the wrist from chains and the provision of inadequate food and water, again without permanent damages, rises to the level of torture. And finally, Nigel Rodley, who was a special rapporteur on torture to the United Nations, in a 2002 comprehensive report, when he looked at all the regional courts and the responses to torture, he specifically said that inadequate food and water and hanging by the wrist from chains are acts of torture. But even if this court, in this case, finds that these do not rise to the level of torture, it would still be cruel, inhuman, and degrading treatment.
And is there universal jurisdiction, or is there jus cogens norm in respect of cruel and inhuman treatment?
Your Excellency has not risen to the level of a jus cogens norm. However, it still violates the International Covenant on Civil and Political Rights, which Adova submits does apply at Camp Indigo. Now, Rotania, on page 17 of their brief, suggested that the ICCPR does not apply in Camp Indigo, namely because the plain language of the ICCPR says it only applies within the territory and jurisdiction of a state. However, when we look to this court's holding on where and when the ICCPR applies, namely the advisory opinion on the Palestinian Wall, the nuclear test case, and the DRC v. Uganda case, this court has continuously held that the ICCPR does apply extraterritorially in a place that a country has control. In this case, Rotania does have control over Camp Indigo, according to the status of force agreement it signed in paragraph 30 of the compromis, and therefore its agents are responsible for violations of the International Covenant on Civil and Political Rights when they occurred there. In fact, Rotania in their brief on page 20 point to the case of Ireland v. the United Kingdom to support their contention that these would not be torture, these acts, but mere cruel, inhuman, and degrading treatment. Because in Ireland v. the United Kingdom, there were 3 similar techniques used, namely sleep deprivation, stress positions, and the use of bright lights. Your Excellency, that's still a violation of international law, and thus Adova can still prevail on this claim, whether or not this court finds torture or cruel, inhuman, and degrading treatment. Now, Your Excellencies might be asking—
Is there such thing as a preemptive self-defense? I don't mean to go back to self-defense, but it's kind of crucial here. Is there such thing as preemptive self-defense?
Your Excellency, Adova submits that there is not as codified by the United Nations, and moreover, that Rotania and their brief are not actually relying on preemptive self-defense, but argue that there was a continuing armed attack going on in this case. If it pleases the court, too, I can also address, if Your Excellencies might be asking yourself, if this situation might change if there's an armed conflict and we actually apply it.
So what you're saying is there's no such thing as a doctrine of preemptive self-defense out there anywhere in the 4 corners of the law?
Oh, no, of course not, Your Excellency. There's certainly states that believe that there are preemptive self-defense. The United States comes to mind as an apt example that has actually decided that in a ticking time bomb situation, for example, picture maybe if one country had a nuclear reactor and there was good evidence that they were going to use it. Perhaps in that very case, a country could act in preemptive self-defense and would often be able to justify this maybe under a state of necessity, which is, of course, codified in the International Law Commission's articles on
So
state
there's only a
responsibility.
ticking time bomb aspect to preemptive self-defense? Is that your assertion?
Yes, Your Excellency, and that preemptive self-defense should not be used if there's not sure information that there is going to be an attack that is going to be launched. In fact, when we look instead to the United Nations and Article 51 in and of itself, it specifically says that self-defense must be first in response to an armed attack committed by that state. And so it's actually a responsive measure. Now, if a country wants to act preemptively, it could try to do that under the justification of necessity. That out of necessity, a country can be precluded from wrongfulness if it's acting in the only way necessary to protect an essential state interest. So if Rotania could today show that this was the only way necessary for them to protect their state interests, they may then be able to rely on a preemptive self-defense notion under the doctrine of necessity.
What is the standard to apply necessity?
Your Excellency, the standard in that case is an objective standard, not a subjective standard, in that according to the International Law Commission's commentaries on Article 25, specifically the ones covered by Judge Ago in 1980. They specifically said that a judicial body should look back and determine whether or not that state of necessity was objectively there, not a subjective reading by the country itself. Now, respondents might even try to use necessity to justify cruel, inhuman, and degrading treatment, but Adova in this case submits that this was not the only way they had to find out important information. In fact, Human Rights Watch, Amnesty International, Rosalind Higgins herself have written extensive reports and have shown that the best way to find information from detainees is building rapport first and foremost, and not resorting to illegal uses.
Can we pay any weight to findings of organizations such as Amnesty or Human Rights Watch?
Your Excellency, not to the organizations themselves, but according to Article 38(1)(d) of this court's charter, this court can look to highly qualified publicists, and Adova submits that Rosalind Higgins...
Are you suggesting that these organizations have reached that level?
Some members, yes, Your Excellency, would be. For example, Kenneth Roth, Adova suggests, would be a highly qualified publicist. But even looking beyond that, again, this court could just apply what the International Law Commission itself has outlined, of course comprised of the most highly publicized publicists. And then they held that the Rotania could not justify, or a state could not justify, cruel, inhuman, and degrading treatment under necessity.
I think you are going to get to telling us why international humanitarian law should not be interesting us.
Yes, Your Excellency. Adova submits it does not apply because in this case there is not an armed conflict. And in fact, according to Rotania's brief, they completely agree with us. However, if this court wants to determine that on its own, Adova submits that it should apply the two-part test outlined in the Tadic decision in the Yugoslavia Tribunal. In that case, the court decided that to determine whether or not an armed conflict exists, one must look at the intensity of the conflict and the organization of the two parties to that conflict. I see my time is up, if I may briefly conclude. And Adova submits that in this case, that the conflict is neither intense enough, nor are the parties organized enough to amount to an armed conflict, and thus Rotania, in this case, violated international human rights law. Thank you.
Thank you, Ms. Day. We would like to hear from your co-agent, Mr. Layton. Please.
Good afternoon, Your Excellencies. If it pleases the court, my name is Alex Layton on behalf of the applicant, Adova. This court, in finding in favor of Adova today, has the ability to affirm that the struggle against international terrorism be waged in accordance with fundamental principles of human rights and respect for state sovereignty. As my co-agent stated, it shall be established in Issue 3 that the Rotanian military commissions must divest jurisdiction over the Adovan citizens because they were illegally captured or subject to a military commission that violates their fundamental due process rights. It will further be established in Issue 4, which is the respondent's counterclaim, that Adova does have the ability to prosecute both former President Kirgov and Professor Vernitsa because neither of the two men have head of state immunity. Now moving to the third issue. There are three reasons why the Rotanian Military Commission must divest its jurisdiction over the Adovan citizens. First, Rotania illegally entered Adova and captured...
Excuse me, I didn't think head of state immunity was a problem anymore in the current state of the law. Do you agree?
No, Your Excellency. Head of state immunity still may apply in instances of immunity rationia personae, which is a status immunity applies to those individuals that are current heads of state. However, the second form of immunity, immunity ration materiae, which is a functional immunity, may apply in certain instances. And that, Your Excellency, is what the respondents claim former President Kirgov has.
Are there any exceptions to that point, or those points?
Yes, Your Excellency. Under immunity ration materiae, torture, use Kogan's crimes, and severe international crimes do not get afforded that type of head of state immunity.
And is there any precedent that you can cite to us for that proposition?
Yes, Your Excellency. If we look to the United Kingdom's House of Lords, in both Pinochet 2 and 3, we find that the House of Lords have found that under customary international law, there is no head of state immunity for acts of torture. Now, in Pinochet 2, all 7 law lords found this. In Pinochet 3, 6 of the 7 law lords found this. 2 of the law lords, Lord Brown-Wilkinson and Lord Seville, found that by signing the Convention Against Torture, there was an express waiver over head of state immunity. Now, Lord Hutton, Lord Hope, Lord Phillips, and Lord Millett both found that under customary international law, there could be no head of state immunity for acts of torture. For those reasons, actually, former President Kirgov could not have that head of state immunity for acts of torture. He also would not have head of state immunity for acts of cruel, inhuman, and degrading treatment. Now again, while it has not risen to the level of Use Kogan's norms, Nigel Rodley, the Special Rapporteur to the United Nations on Torture, has actually said that cruel, inhuman, degrading treatment has risen, but not going that far.
So what you're saying is torture is not an international crime?
No, Your Excellency, it is an international crime. It's a Use Kogan's crime, and it's prohibited from any state to take part in that. But additionally, even if this court were to find that torture did not occur here, but cruel, inhuman, and degrading treatment did, that would still pierce former President Kirgov's head of state immunity.
Why do you think the Convention makes this distinction between torture on the one hand and cruel, inhuman, degrading treatment on the other?
You actually, torture is a very severe international crime, and it's a crime that is prohibited under international law. Now, cruel, inhuman, degrading treatment is also a violation of international law, but is not as egregious as torture. Regardless, though, the international community has roundly condemned the use of cruel, inhuman, and degrading treatment, as can be seen by its prohibition in Article 5 of the American Convention on Human Rights, Article 5 of the African Charter on Human and People's Rights, Article 7 of the International Covenant on Civil and Political Rights, Article 16 of the Convention Against Torture, Cruel, Inhuman, and Degrading Treatment, Article 3 of the European Convention of Human Rights, and Article 5 of the Universal Declaration of Human Rights.
What's a severe international crime versus a non-severe international crime?
Your Excellencies, judges on this court, Judge Kujerman, Judge Bergenthal, and Judge Higgins in the Belgian arrest warrants case said that severe international crimes cannot be given cannot be protected under head of state immunity. Now, these judges clearly understood the difference between a Use Kogan's crime and a severe crime under international law. By saying severe international law, violation of severe international law, they understood that such incidences like cruel, inhuman, degrading treatment could also not be protected under head of state immunity. Therefore, Your Excellencies, Adova submits that regardless of whether or not this court finds that torture occurred or cruel, inhuman, degrading treatment, former President Kirgov does not have head of state immunity. Now, respondents do argue in page 42 of their brief that Professor Vinica may have immunity ragione personae, which is a status immunity, for his acts as an advisor to the foreign ministry. However, that would be a gross overreading of this court's own holding in the Belgian arrest warrants case. Notably, in paragraph 51 of that case, the court found that immunity applied to those who are heads of government, heads of state, and foreign ministers. Paragraph 38 of the compromise says explicitly that these individuals are outside of the foreign ministry, thus one can imply that they are not officials. This would be akin to giving former president of the American Society of International Law, Jose Alvarez, who's a professor at Columbia University and an advisor to the State Department on international law, head of state immunity. That would be a gross overexpansion of this court's own holding in the Belgian arrest warrants case.
Indeed.
Therefore, Your Excellencies, head of state immunity cannot apply to either former President Kirgov or Professor Vinica for their crimes.
Do I hear you to be saying, though, that the giving of legal advice by a government lawyer, and in particular a government military lawyer, could be on its own a violation of international law?
Your Excellency, the individual could be held responsible if he gives illegal advice that contravenes international law. In this particular instance, former Professor Vinica could be liable for those acts. But additionally, he does not...
But I'm asking you on what basis?
On what basis, Your Excellency? In the Nuremberg tribunals, they found that Mr. Ribbentrop, who was given advice to then dictator Hitler about how to invade some of the European countries at the time, that he was found to violate international law by giving that legal advice. So there is international precedent for finding legal advisors liable for acts of violate or contravene international law.
Any case other than the Nuremberg case of which you are aware?
Your Excellency, they've gone all the way through prosecution and conviction. That is the one I am aware of.
Thank you.
Although there have been others that are currently in the process.
I will let Mr. Alvarez know. You can rest.
If it pleases Your Excellencies, I'd like to move back to the third issue, which is whether or not these individuals had their rights violated when they were illegally captured and are subject to the military tribunals. You actually, there are three reasons why the Rotania Military Commission must divest their jurisdiction. First, they were illegally captured. Second, upon capture, they were subject to torture or cruel, inhuman, and degrading treatment. And third, they are subject to a military trial that violates their fundamental due process rights. Now, under the first point, Rotania illegally entered Adova and kidnapped Adovan citizens and are continuing to detain them under principle of mala captis bene detentis, which translates into bad capture, good detention.
Wasn't that an act of self-defense of going in and getting the individual?
No, Your Excellency, it was not.
Why is that?
Your Excellency, because as my co-agent has established, that they did not correctly adopt the requisites of self-defense, and that, Your Excellency, there can be no act of self-defense in this particular instance because Adova had explicitly told the Rotanian government that they were going to prosecute these individuals themselves as soon as they got their hands on them. And this is what Adova asks this court today, is to return these individuals to Adova so they can face trial in Adovan criminal courts.
So what should Rotania have done in the face of the non-compliance with the Security Council resolution?
Your Excellency, Adova submits that they have not necessarily not complied with the Security Council resolution, that these individuals were captured before the 15 days had expired. However, Rotania could have shared their information and intelligence with Adova because clearly Rotania knew where Samara Penza and the other lapsed members were located in Adova. Adova may not have the structure to have found them on their own, but Rotania could have shared that information with Adova. Additionally, Rotania could have beefed up its border security, could have done better things to make sure that there couldn't be such infiltration from Adova into Rotania. Now, the principle of mala captis bene detentis, while it has been around for hundreds of years, the response would have a hard time pointing to any domestic case in the last 20 years outside of the United States that continues to uphold this principle. In fact, looking to the United Kingdom, in ex parte Mackerson and ex parte Bennett, the House of Lords found that due to evolving standards of human rights, this principle of mala captis bene detentis does not have a place. This is also upheld.
What does that Latin term mean again?
Sorry, Your Excellency. It means bad capture, good detention.
Okay.
This was further upheld in New Zealand versus Hartley, in State versus Ibrahim in South Africa, and State versus Behim in Zimbabwe. Now, Your Excellencies may be asking yourself, what about Prosecutor v. Nikolic before the Yugoslavia Tribunal? Now, while the court did analyze the concept of mala captis,
What's the standard? What is the standard that would throw something like this out of court due to jurisdictional issues?
Your Excellency, because the individuals were illegally captured and brought into Rotania and brought before the court, that would violate.
Under whose perspective that they were illegally captured?
Your Excellency, Adova submits on that, looking to Prosecutor v. Nikolic, the court there found that when a state actor is involved in actual kidnapping and abduction of the individuals and then rendering them and bringing them before that state's own court, that the court cannot hold jurisdiction over the individuals because of the way they were brought forth before it.
And what is the standard that throws a case out from your perspective?
You actually, the fact that the respondents or the fact that the state involved actually had their hands involved in the kidnapping, that it taints the court and it taints the jurisdiction of that court for continuing to try the individuals.
Just for going out and getting the individual? What if they just drove over and through subterfuge and promises of wine, women, and song, he gets in the car and they just drive across the border? Is that wrong?
You actually, that's actually different. That would be considered luring in this court and the international.
Luring?
Luring, Your Excellency.
Okay, just want to make sure. Okay.
That would be somewhat different because the individual, would be getting into the car on his own free will.
I'm not the brightest person in the world, but I've never heard of the term luring. Explain, please. Where do you get that proposition?
That was in Prosecutor v. Dokmanovic before the Yugoslavia Tribunal. And at that point, they lured the individual across lines, and they found that they had jurisdiction over the individual because he left and crossed on his own free will. But
what did the judges in Dokmanovic indicate? Wasn't there some obiter dictum? Didn't they leave open the question of using force on the part of the prosecutor's office?
That's what I was trying to get you to say, too. Go ahead.
Well, Your Excellency, Adova submits that there was use of force in this particular instance when they kidnapped Nikolic, when they kidnapped Nikolic, but the court found in Nikolic that the reason they had jurisdiction over the individual was not because they adopted this principle of mala captis, but because of the unique vertical relationship the court had with the countries involved in that particular incident. And here, Your Excellencies, we have a horizontal relationship between two sovereign states, and does not give the right of Rotania to then violate Adovan sovereignty and kidnap Adovan citizens.
Is there any reference to this issue in the Rome Statute?
I'm not aware, Your Excellency. Now, regardless of whether or not you find that you will uphold this concept of mala captis bene detentis.
Sorry, before you leave that, my understanding of the Rome Statute is that when somebody is arrested pursuant to a warrant issued by the International Criminal Court, the arrest has to be confirmed by the local court, by the domestic court.
Well, if that's the case, Your Excellency, then Rotania has violated also the provisions of the Rome Statute because they did not get the authority of Adova to arrest these individuals. Additionally, there has been no arrest warrant issued for Samara Penza and the other lapsed members, and neither of the two parties are signatories to the Rome Statute. Now, even if this court were to find that the principle of mala captis benedictentis still applied,
I'm still hung up on the
Sorry.
wrongfully captured part of it. What's the spectrum then? You know, we've got this wonderful word luring, all right, and what's the other part of it? What's the opposite of luring? What gets it thrown out of court? Luring, you're in court. What's the opposite of luring?
the opposite of luring, Your Excellency, is when that state's actors and military actors or police or anyone enters into another country, forcibly kidnaps that individual, and brings him back across the state lines. Now,
Forcibly kidnaps? What do you?
or just kidnaps the individual. But the difference in the line I would like to draw here is that there's a difference between one's own free will and one's being grabbed and kidnapped, put a bag over his head, and being forced across state lines.
Just putting a bag over his head, rendering him, I don't mean to, this is important. This is important because it's a distinction that really changes the outcome. They kick the door down, they go in, they club him, they knock him out, they drag him out, and throw him in the back of a cold van and take him across the border.
Yes, Your Excellency.
What's going to be the result based on the case law?
If those individuals were state actors of the state that they were rendering them to, then that would be a violation, and that would require the court to divest its jurisdiction over these individuals.
A violation of what?
The violations of the individual's own personal human rights and a violation of the
on what?
state's sovereignty.
Based on what?
On his Article 9, Your Excellency, of arbitrary detention, and then it would also be subject on the second part of mala captis, is that he's treated fairly and humanely and upon detention. And that is, even if this court were to find that this principle still applied, then upon detention, these individuals are subject to cruel, inhuman, and degrading treatment or torture. And according to Prosecutor V. Nikolic in paragraph 28, the court found that if they saw that Mr. Nikolic had been subject to torture or cruel, inhuman, and degrading treatment, they would have let him go. However, the court only found that he was roughed up. Now, even if this...
What if they only intended to lure, but yet he wasn't willing to be lured and he puts up a hell of a fight?
Well, Your Excellency...
What's the result there?
Well, Your Excellency, that...
And they have to do self-defense, they have to defend themselves.
Well, see, the distinction I'm trying to draw between luring and one's own free will is that when you're lured, you believe something else is going to happen, and then you go across those lines with those beliefs on your own free will. However, if someone forces you to cross those lines against your free will, that is not luring, and that is becoming a capture.
Okay, proceed.
Your Excellencies, because he was later subject to torture or cruel, inhuman, degrading treatment, and the court, Nikolic also noted that if someone were subject to those methods, that a court would have to divest its jurisdiction over them. Otherwise, they would be rewarding police brutality and lawlessness.
Was he tortured before or after he was brought across the border? Does that make a difference?
Are you talking about Mr. Nikolic?
Yes, when they rendered him to the third country.
Your Excellency, it was unclear from the facts what had occurred to him. They just merely found that he was roughed up, and it seems like he was roughed up from the time they had captured him and between the time they handed him over to NATO forces in Bosnia. So in that period of time, he was subject to, we don't know exactly. However, in that period of time, that still falls under the good capture portion of this theory, and they found that he was still detained humanely. However, here they were not, because they were subject to torture, cruel, inhuman, degrading treatment during their detention. That violates international law and requires the court to divest its jurisdiction. Additionally, the military commissions that were established to prosecute these individuals violate these individuals' fundamental due process rights. Now, regardless of whether or not international humanitarian law or international human rights law applies, the respondents have conceded that there is no armed conflict, so international human rights law should apply. But if this court finds otherwise, according to this court's own precedent...
What's the standard under international humanitarian law related to a commission like this?
You actually, a commission is still allowed to function, and Adova does not submit that the military commission cannot be created. It simply submits that the rules and procedures of this commission violate these individuals' due process rights. And according to this court's own holding, in the advisory opinion of the nuclear test case in paragraph 25, and the advisory opinion on the Israeli wall case in paragraph 105, 106, and 107, regardless if we have an international humanitarian law or if we have an armed conflict.
What did the Geneva Convention say about this standard?
Under Common Article 3, it requires that all individuals not be subject to torture or cruel and degrading treatment.
Understand
as
that.
as well as have, if we find that there was an armed conflict, that they and their POWs, then these individuals would have afforded access to legal counsel of their own choosing.
Do they have to be PWs?
And if we find that there was an international armed conflict, Your Excellency.
What if they're not?
If they're not, then it would be additional protocol, optional protocol 1, paragraph 75, does afford these individuals particular rights that are also codified in Article 14 of the ICCPR.
What does regularly constituted court mean to you?
You actually, a regular constituted
And
court.
where do you find that?
Actually, that's also found in the Geneva Conventions in Common Article 3. And the regular constituted courts that provides all the trial and due process rights afforded to all people under civilized nations, that Adova's requests means that those are the provisions that are outlined in Article 14 of the ICCPR, and that is what is also included in Common Article 3 of the Geneva Conventions. And if we find that international human rights law applies, we see that there is a violation of Article 9 of the ICCPR. That's because the individuals were captured and were not brought properly before court to hear the charges against them. Now, the Human Rights Committee, which is responsible for looking at the ICCPR, and Stevens versus Jamaica and Fremantle versus Jamaica, found that detention longer than 4 days violates the individual's fundamental or arbitrary detention. Additionally, the Human Rights Committee in Brogan versus the United Kingdom, the European Human Rights Committee in Brogan versus the United Kingdom, found that detention of greater than 4 days also violated Article 9 of the ICCPR. According to paragraph 31 and 37 of the compromise, these individuals were detained for 3 weeks and they were not brought promptly before court to hear the charges against them. Additionally, these military commissions violate Article 14, and that they don't allow counsel of one's
Article
own
14
choosing.
of what?
Of the ICCPR.
Okay.
They do not allow counsel of one's own choosing. They allow the use of anonymous witnesses, and they allow the use of coercive testimony. Now, access to counsel of one's own choosing was also upheld in the Human Rights Committee, and Lopez.
What's the standard? Is it an international standard, or is it domestic law standard based on Rotania?
Actually, it's an international standard because it's an international covenant that both countries are parties to and requires them to have access to counsel of their own choosing.
But what if Rotania, under its own domestic law, constitutes a commission based on its own law and continues to move forward on that?
That law has to be in accordance with Article 14 of the ICCPR unless they officially derogated from it under Article 4. Now, they have not officially derogated from this under Article 4 because they did not notify the Secretary General of the UN of the provisions they're derogating from and the reason for their derogation. And then a caveat to that is that exigent circumstances must also exist. Now, according to paragraph 22 of the compromise, the last attack happened in February of 2001. That was over a year ago. Additionally, in paragraph 31, then Colonel Benitez said that the reign of terror was over. Now, that was in April of 2007. It's been 1 full year. There is no longer an exigent circumstance to justify the stripping of these individuals' fundamental due process rights under Article 4 of the ICCPR.
Counsel, your time is very short. Which of the alleged deficiencies in due process do you think should be of most concern to us?
The right to access of counsel on one's own choosing, Your Excellency. In addition,
Do you think that's more important than use of coerced testimony?
And I was going to say, and the use of coerced testimony as well. Those two are fundamental.
Very quick answer. Thank you.
Your Excellency, according to General Comment 7 of Article 7 of the ICCPR, the Human Rights Committee has stated that any use of torture or coercive testimony cannot be used in any trial. Your Excellencies, in finding in favor of Adova, you have the ability to cement 2 fundamental principles of international law today: the inviolability of state sovereignty and the respect for human rights. Thank you, Your Excellencies.
Counsel, I have, I'll
sure.
use my prerogative to ask you one question, and of course give the other side the same question in the same time. Are you, just to clarify, are you asking that the court order the release of General Vinitsa and the dismissal of the indictment against former President Kirchhoff?
No, Excellency. We're arguing that we have the ability to try Professor Vinitsa in the Adovan courts, and that we are able to issue a red notice for the arrest of former President Kirchhoff to try him in Adovan courts.
So you're not asking for any such affirmative relief from this court?
No,
Is
Your
that
Excellency.
correct?
In that particular issue, we're simply asking you to reject the respondent's claim on their counterclaim on that particular fact.
Thank you.
Thank you, Your Excellencies.
Now, if I might ask the first co-agent from the respondent to come forward, please. Please.
May it please the Court, Madam President, Your Excellencies. My name is Brent Michael, and together with my co-agent, Mr. Mann, I appear on behalf of the State of Rotania, respondent in this matter. We divide our time 22 minutes and 21 minutes respectively, thereby leaving 2 minutes for rebuttal. Your Excellencies, the State of Rotania was the victim of a series of vicious attacks to which it responded lawfully in order to protect the lives of its citizens, its culture, and its property. Accordingly, the respondent makes 4 submissions. First, that the apprehension and rendition of Ms. Penza was a lawful exercise of self-defence. Second, that the treatment of the individuals in Ms. Penza at Camp Indigo did not violate human rights obligations. Third, that the prosecution of those detainees before the Rotanian Military Commission complies with standards relating to fair trials. And fourth and finally, that the applicant's attempted prosecution of Rotania's former President Kurgov and General Vinitsa is in violation of the respondent's right to assert immunity. I'll deal with the first 2 of those issues and my co-agent the third and fourth. Turning to the first of those issues, Your Excellencies, the entering into Adovan territory and seizing of Ms. Penza was a lawful exercise of self-defence pursuant to the United Nations Charter. Under Article 51 of that Charter, all states have an inherent right of self-defence in response to an armed attack. And there are 3 requirements for self-defence which must be established. First, that there is an armed attack. Second, that the response was both necessary and proportionate. And third, that there is some level of attribution from the entity against which self-defence is being exercised in connection with the armed attacks that were carried out. Now, the focus of those issues today by the applicant in their case has been on the particular issues of attribution. And so I'll turn to that first.
Why does it have to be an armed attack as opposed to an unarmed attack? Can it be done through cyberspace?
Your Excellency, armed attack is a requirement under the United Nations Charter. The question of what constitutes an armed attack was not defined in the Charter. The court in the Nicaragua decision of 1986 held that the attack must be of sufficient gravity. Of course, that definition may change over time so that sufficient gravity with modern technology might constitute an armed attack by instance, for example, shutting down a defence computer network, which may be sufficiently grave and yet not the conventional type of armed attack that's been traditionally seen. And of course, the requirement of conventional weaponry is not a prerequisite to an armed attack, as this court held in a nuclear weapons advisory opinion, but more importantly, the recent state practice surrounding September 11, where we saw aeroplanes used as a weapon and not guns or bombs. Your Excellency, if I might turn to the attribution requirement, the applicant submitted that the entity against which self-defence is being exercised must be in some way responsible for carrying out the armed attacks in the respondent state.
Is the ILSA a belligerent in this situation?
Your Excellency, it is, in our submission, an insurrectionist movement. We do not submit that there is any armed conflict in the present proceedings or in the present scenario, and we agree with the applicant on that point.
What's the definition of a belligerency?
A belligerency, in our submission, it would be a group, a non-state actor which is fighting the government of a particular state. Your Excellency.
Is there any other standard? Just fighting? I mean, it could be, what you're suggesting, it could be a riot. Is a riot fall under this category?
A certain level of protractedness would have to be established.
Can you give me a conflict spectrum going from one side to the other, which constitutes a police action versus something that falls under, even minimally, a non-international armed conflict?
Your Excellency, a group struggling for self-determination in the face of perhaps an oppressive regime which is using force back would be recognised as a belligerent. But in any event, the recognition of what this particular group is not relevant to the legal right of the state of Rotania to exercise self-defence, even whether they're
Why isn't that important?
because the test of self-defence in its requirements does not have belligerency as a requirement. There must be an armed attack, the response must be necessary, and there must be attribution. There is no requirement that a particular group fall within a certain class of militant or terrorist organisation or anything of that sort. Your Excellency, we accept that the attribution requirement of self-defence must be made out. But in contrast to what the applicant has submitted, the test is not one of effective control, as this court held in the Nicaragua case of 1986. In our submission, the test is one of unwillingness or inability to prevent one's territory.
Well, what is the evidence of unwillingness in this case?
The evidence, might I just come to that in a moment, because I believe that Your Excellencies might not be, unless Your Excellencies prefer, you're right, I have a lot of work to do in establishing this particular test in the face of this court's previous decision.
So you're telling us you'd like to move on?
I'll move on now if Your Excellencies prefer, but that is, if you are satisfied that that test is made out, it may be convenient to come to that after establishing the particular legal doctrine.
I don't think we're prepared to give you any undertakings.
Certainly, Your Excellency. But in viewing what is unwillingness or inability, it is necessary to look at first at what the test is in order to establish that.
And you're going to tell us this test?
That's correct. Now, the test as set out in this court, previously being effective control, as held in the Nicaragua case, is no longer the test. What we see throughout the 1990s and crystallising in the events surrounding September 11 is that states have exercised self-defence against other states when there are non-state actors operating from their territory which are not attributable to that state in the traditional effective control sense. And we submit that a new norm has crystallised, and the evidence of that, we submit, is the September 11 response by the United States. When the Al-Qaeda organisation carried out armed attacks on America, the United States invaded Afghanistan in circumstances where there was no effective control on the part of the Taliban, which was the de facto government at the time, and the non-state actor concerned, namely Al-Qaeda. And yet there was near unanimous international support and approval by the international community in that situation, reflecting a very clear acceptance and widespread opinio juris that that would be an acceptable norm of attribution. Additionally, 18 or 19 states participated in the act of itself. State practice, again supporting that the norm is not one of effective control. Your Excellencies, if the norm of effective control is not the test for attribution, the question becomes, what has replaced it? Because if the international community accepts that that's no longer the test, there must be some new test. And in our submission, there are two possibilities. One, the attribution requirement may have been removed altogether, so that you don't need any culpability on the part of the state. The other possibility is that the threshold for attribution has been lowered to one of effective control, to one of unwillingness or inability. In our submission, the better view is that it is one
What's
of...
the precedent for that assertion?
Well, there are 2 points. First of all, it accords with what the United States argued prior to going into September 11, that tolerating individuals on its territory they would enter into the territory if that was the case, and they did, and there was approval of that by the community. But also the Organisation of American States, as well as the European Union, both said that if a state tolerates terrorists or other irregulars operating from a particular territory, then that state would be responsible for those particular attacks that those individuals carry out. And so this is not just acceptance in a political sense of the United States' actions, this is acceptance of the particular legal doctrine which we propound is the test for attribution.
You said legal doctrine, but you didn't state any legal precedent for that assertion.
Your Excellency, we submit that this is a customary rule evidenced by state practice according to this Court's Charter under Article 38. And so the emergence of a customary norm is the precedent that we rely on. Your Excellencies, there's been judicial acceptance that the effective control test is not the test, as evidenced, for example, by Judge Higgins, Judge Queenmans, and Judge Bergenthal in the Israeli wall case. More recently, Judge Kartakar in the Congo and Uganda case of 2005 specifically said that the test was not effective control, but one of unwillingness or inability. There is state practice to support this, as I noted earlier, as all throughout the 1990s and beyond, we see states going into other states' territories in the absence of effective control, such as Tajikistan, Thailand, Senegal, the United States, in Afghanistan, the PKK being exercised self-defense against in Iraq, and a variety of other states. Now, Your Excellencies, if this is the test which we submitted is, as evidenced by accepted opinio juris by the entire world, absent a couple of states who objected in September 11, then the question becomes, is that test satisfied?
How does something become customary international law? What's the general rule?
The test is near uniform or consistent state practice, as this court laid down in the North Sea continental shelf cases, Your Excellency.
Consent throws anywhere in there at all?
Beg your pardon, my apologies.
Consent to be bound or following that rule anywhere in there?
Opinio juris reflecting that states feel that they are bound by that particular rule, and state practice being states actually conducting themselves in accordance with that rule.
So the U.S.'s action after 9/11 started a process or culminated in a process by which states consented to be bound as a practice?
Culminated, Your Excellency.
I'm just not following you on that.
My apologies, Your Excellency. Our submission is that state practice throughout the 1990s and beyond has involved states using self-defence in an absence of the attribution requirement. Then the United States, in the response to September 11 attacks, again exercised self-defence in the absence of attribution, and there was acceptance of that by states, reflecting opinio juris, and there was practice of states actually participating in the invasion, reflecting state practice. Your Excellencies, applying that test to the present facts, what we see is that the applicant was unwilling or unable to prevent its territory from being so used. First of all, we have 4 particular circumstances which, whilst one alone might not lead one to that conclusion, put together evidences clear unwillingness. First of all, we point to the fact that there were no steps taken at all by the applicant to take any measures at all to prevent its territory from being used by these irregulars in a hostile way. There is no evidence that they have conducted...
But what use of the territory was being made?
In our submission, it was used as a base of operations for Ms. Penza as head of the organisation, which was being a branch of which was carrying out the attacks. And indeed, Ms. Penza was an international fugitive, as the Security Council had called for her to be...
Is there any evidence that the applicant knew where Ms. Penza was?
That the applicant knew, certainly not, Your Excellency, in the sense that the applicant did not know her exact location, but that would probably be because the applicant had not searched for Ms. Penza. And in our submission, that evidence is an unwillingness, or goes towards an unwillingness, that state was willing to do anything in response to this particular organisation, which was known to be carrying out the attacks. In addition, it refused to certify to the international community that it had conducted a search or would conduct a search. And whilst it said it would carry out its own legal investigations, there is no way of knowing either the respondent state or the rest of the Security Council or any state in the world whether such a search would be carried out. And so there is no accountability there.
Mr. Michael, let me jump you past the attribution test. I think we understand where you are on that, to the very important question of necessity. My colleague's question focuses on a question I have, which is why Rotania thought that capture of Ms. Penza was so important as compared to, example, for cutting off the funding to ILSA within Rotania, using economic sanctions, freezing bank accounts, setting up blockades to stop any transfer of funds or ammunition. Why the focus on this one person to protect you from all the things that you were worried about?
Well, Your Excellency, Ms. Penza is the head of the organisation, as well as being surrounded by her closest operatives. Cutting off the head of the organisation would, in our submission, disable that organisation from operating effectively. The instructions, the command centre, the nexus of its directions.
That's exactly my point. Are there not other ways to cut off an organisation from its head, short of entering the territory of another country?
Well, in our submission, there aren't, Madam President, given that the respondent state had approached the Security Council to operate in a peaceful and collective fashion, taking diplomatic measures to call upon the respondent state to act. The respondent state had refused to search, refused to do anything.
But couldn't you have gone back to the Security Council for further measures?
We could have, Your Excellency, but we knew in any event that the applicant state had refused to comply with what the Security Council had done in any event. And so it would be a futile act in our submission to go back to the Security Council when we already knew that the applicant state was failing or indicated that would not comply with it.
But the Security Council hadn't taken any measures to compel.
No, it had not, Your
And
Excellency.
why are you ruling out the efficacy of that route?
Because, Your Excellency, the requirement of self-defence does not necessitate that a state be authorised by the Security Council to act. It's a standalone right, it's an inherent right. And so we submit that the Security Council approving the respondent state's actions is not a condition precedent to their validity. Your Excellencies, might I also note that the applicant stated that the respondent state could have increased border security and so forth. But in our submission, there was already ample security around the Shrine of the Seven Tabernacles and other areas in the upland plateau. Your Excellencies, might I turn to the second of our major submissions regarding the treatment of the individuals. In our submission, there are 2 points to make here. The first is that the treatment of the individuals at Camp Indigo cannot be demonstrated to be torture. And the second is that whilst they may be demonstrated to be cruel, inhuman and degrading treatment, the wrongfulness of the state of Rotania is precluded by the doctrine of necessity. Now,
Mr. Markle, is it your submission that hanging people by their wrists and cutting off their regular food supply is acceptable treatment under international law?
in our submission, Your Excellency, it would depend upon the particular facts of the mechanism by which these acts were carried out.
Well, they were particularly hung by their particular hands against that particular hook.
With their
That's quite-
particular no clothing.
That's quite right,
Food
Your
or
Excellency.
comfort.
But the test for torture is...
Go ahead.
The test for torture...
I'm just asking you, leave aside at the moment the distinction between torture and cruel, inhuman and degrading treatment. My question, and I don't think you've answered it, is it your submission that this treatment is lawful under international law?
This is precisely the respondent's point, that one cannot make an a priori assertion that particular acts would always constitute torture or not, where they're in the middle of the spectrum. Some acts will never constitute torture. Some acts will always constitute torture. In our submission, there are a range of acts in between on that spectrum, which would depend upon the particular circumstances of the case.
Now you're going into spectrum, and you know that I like spectrums. You went one way, then the other. What is the outer limits of both not torture and absolutely torture?
Well, in our submission, Your Excellency, it depends upon the severity of the harm, or the severity of the pain and suffering, which is the test for torture.
So it's a scale of pain.
That's correct, Your Excellency.
I see.
So whilst we might say that waterboarding in all circumstances, there's no way one can conduct waterboarding without causing severe pain. And whilst one might say that patting someone on the back or a certain level of vigorousness might never constitute torture, holding someone in chains, depending upon the means of that particular act, could cause different levels of pain. They might be secured for security, they might be secured to cause arm paralysis, we just don't know. The crux of our submission is that the burden is on the applicant to demonstrate beyond a reasonable doubt, which is the test espoused by the European Court of Human Rights and the test espoused by this court in the genocide case, that the amount of pain inflicted was severe. And there is no evidence of the circumstances of each particular act. We don't know the length of time each act was carried out. We don't know the level of discomfort. We don't know whether they were all carried out cumulatively or not. We don't know any long-term damage. And we don't know the psychological harm that was carried out, for instance, on Mr. McCarr or the other detainees.
Is there any legal precedent on this pain standard of torture?
Yes, Your Excellency. It's defined in Article 1 of the Convention Against Torture, which sets out the definition, as well as being recognised as the customary definition of torture under the Furazinja case and the Chronologia case.
So you're asserting it's only pain that defines it as torture?
That's correct, Your Excellency, but that pain can be mental or physical. Your Excellency, this particular reason, in the absence of the evidence of the circumstances, was one of the reasons that the Third Circuit of the United States Court of Appeals, in the Rakit and Ashcroft case of 2004, held that even where there is some evidence of certain acts of torture occurred, this is inconclusive where we don't know the particular circumstances of the acts. Your Excellencies, because torture is supposed to be assessed on a case-by-case basis, that is, one cannot simply look to a previous case and say these acts were held to be torture in that case.
Would Common Article 3 apply to the situation after you rendered them from the state to you have them in detention? Does Common Article 3 apply to the situation?
Your Excellency, the requirement under Article 3 not to carry out torture or cruel and inhuman degrading treatment would be the same under the ICTR and the Convention Against Torture, to which we are a party. So that very obligation binds us effectively anyway. And so we accept that that particular obligation does bind the respondent state.
Common Article 3 of the Geneva Convention says what related to?
It sets out a list of guarantees which states cannot carry out in times of armed conflict, Your Excellency.
Does it talk about humane treatment?
It does. It says
Is there anywhere in here, is that what you're asserting is what you've done or in this particular camp humane?
Your Excellency, that would go to the lower level of acts carried out here, namely cruel, inhuman and degrading treatment. And we submit that these acts are in the range of spectrum which we could say they would always constitute cruel, inhuman, degrading treatment. But the wrongfulness of the respondent state is precluded in this case by virtue of the doctrine of necessity. May I just note before moving to that doctrine, Your Excellencies, is that there's a high test for establishing
what
torture.
you're saying is I can torture because it's necessary to torture them.
No, Your Excellency. Torture is a jus cogens norm, and the doctrine of necessity can never be pleaded in relation to a jus cogens norm. So we only plead it in relation to cruel, inhuman and degrading conduct.
So you can degrade somebody if it's necessary.
Your Excellency, under the state responsibility articles, under Article 25, states may carry out, if the particular acts carried out by a state were the only means of safeguarding an essential interest of the state from a grave and imminent peril, then yes, the state's wrongfulness is precluded at international law.
What's the grave and imminent peril here?
In our submission, the grave and imminent peril is the threat to the lives of Rotanian citizens and the unity to the Rotanian state. The Security Council itself recognised this threat as, quote, serious and imminent. And in our submission, that reflects a pending threat and one in which this doctrine would rightfully apply. Your Excellencies, might I just note, my time has expired, if there are no further questions.
If you would like a few seconds to sum up your position, feel free.
Your Excellencies, it is our submission that there was attribution made out through unwillingness and inability, and therefore that requirement of self-defence is established contrary to what the applicant has submitted. And second of all, there is insufficient evidence for the applicant to satisfy the burden of proving that there is severe pain or suffering. May it please the Court.
Thank you, Mr. Michael. May I invite your co-agent to the podium, please? Please.
May it please the Court, Madam President, Your Excellencies, I will address Rotania's third major submission, that we may lawfully prosecute the lapsed detainees before the Military Commission, and Rotania's fourth major submission, that Adova has unlawfully exercised jurisdiction over former President Kurgov and General Vinitsa, as it is a violation of their right to state immunity. Turning first to the issue of prosecution, and here Rotania makes two submissions. First, that there is no customary rule of international law requiring that a domestic court decline jurisdiction after either an unlawful capture or a violation of human rights. And second, that the individual rules of the Military Commission are a lawful derogation under Article 4 of the ICCPR. Turning first to the question of divesting of jurisdiction. Now, the applicant has contended that state courts may not apply the principle of mele captus bene detentis when there has been an unlawful capture or a breach of human rights. We submit that the starting point for this court is the statements made by the predecessor to this court in the Lotus case, and this court itself in the Nuclear Weapons Advisory Opinion, namely that whatever is not prohibited at international law is permitted. Accordingly, the onus is on the applicant to establish this rule, and this requires a demonstration of consistent and a uniform state practice and statute opinio juris. What the applicant has in fact shown in relation first to a violation of sovereignty is 3 domestic cases from New Zealand, South Africa, and United Kingdom. Now, we submit that those 3 cases, to begin with, were decided as a basis of domestic discretion, a question of internal law relating to abusive process, and that in any event, there is contrary state practice to set against this rule. For example, in 1960, during the Eichmann proceedings, we note that the Security Council passed a resolution after Israel violated Argentina's sovereignty by abducting Eichmann, in which it both acknowledged that Argentina's sovereignty had been violated and also affirmed Israel's right to prosecute. Now, although Argentina later waived the violation of its sovereignty, this resolution was passed prior to that, indicating that the Security Council, at the very least, considered the 2 issues of violation of international law and domestic prosecution to be separate questions. We also, of course, refer to the practice of the United States, for example, in the Alvarez-McCain decision in 1992. Now, the respondent acknowledges that there was a degree of international reaction to that decision. There were protests, for example, by the Latin American states. However, we submit that this protest can be distinguished as a response to a fear that America was asserting a right to violate other states' sovereignty, as opposed to a reaction against the American court exercising jurisdiction. And in August 1992, the US legal department issued a statement clarifying the United States' position on this point. As for the question of a breach of human rights, the applicant has provided before this court 1 case, the case of Nikolic. Now, the respondent submits that the Nikolic case, in setting out the requirement that if one state's agents commit torture or cruel and human degrading treatment, in itself relied upon, for example, the Toscanino case from the United States. And in the Toscanino case, the United States Court of Appeal ruled that the breach of human rights would only cause the court to decline jurisdiction when it was unreasonable or unnecessary. And here I rely upon my co-agent submissions in relation to necessity precluding the wrongfulness of cruel treatment, as meaning the Toscanino exception does not apply. And as this exception was a fundamental underpinning to the Nikolic decision, this rule has no application in the present case.
So what is the mistreatment standard then?
According to a 1995 decision in the United States Court of Appeal, it must be torture, and it must be carried out by the state's agents. If the court has no further questions on that point, I would turn to the rules of the commission itself.
So what you're saying, if they torture the individual, then that's okay. Or that's not okay. Excuse me.
The respondent's primary submission is, of course, that no torture has occurred. And we submit that the rule of custom could still not be met for torture. Given, for example, the ruling of the UN Working Group on Arbitrary Detention in 2005, in examining a case between Dodd and Mexico, where it held that a conviction based entirely on torture-derived evidence could not be allowed, but still recognized Mexico's right to prosecute a person when its state agents, its police, had tortured him. If I might turn then to the second of the respondent's submissions in relation to prosecution, that of the rules of the Military Commission itself. Now, the respondent accepts that the rules of the Military Commission are not in compliance with Article 14. However, under Article 4 of the ICCPR, the Rotania may lawfully derogate from these rules. In order to establish a lawful derogation, the onus is on the respondent to show the existence of a national emergency and that the measures taken in response are necessary and proportionate. The applicant has submitted that the breach of the notification requirement means that Rotania cannot derogate at all. However, in regards to this, although we acknowledge there has been a failure to comply with Article 4, subparagraph 2 of notification, this first is not a condition precedent, it's not a condition precedent to the exercise of derogation. And indeed, it is comparable to Article 51 of the UN Charter, in which self-defense and the exercise of it requires notification. Yet this court held in the Congo and Uganda case that a failure to notify goes only to the bona fide exercise of that particular right, as opposed to the substantive right in itself. And in the present case, given that at paragraph 25 of the compromise, Rotania has publicly proclaimed the national emergency, and further went before the UN Security Council with full openness about the procedures before which these individuals will be tried, Rotania's bona fide exercise of derogation can be made out. Turning then to the other requirements. In relation to the existence of the national emergency, we note the applicant has contended that this emergency is no longer in existence. They referred, for example, to a statement by General Vanitza, in which he said, upon capturing Samara Penza and the other detainees, that, I quote, "their reign of terror is over." Now, in regards to this, first, this referred to those specific individuals. Those individuals had been apprehended. They themselves could not carry out further attacks against the Rotanian state. It does not go to the situation in Rotania itself, nor does it affect the fact that ILSA and LAPS are large, broad-based organizations operating within the Upland Plateau, with a large number of people who still hold very negative feelings towards the Rotanian state. Indeed, the fact that this statement was made cannot affect the reality on the ground. We refer by way of example to President Bush declaring mission accomplished in 2003 in Iraq. It doesn't alter the real security situation that Iraq, or in this case Rotania, faces. We also note that even though there haven't been, to the knowledge of the parties, any further attacks since February 2007, in, for example, Northern Ireland, the fact that there is a ceasefire in place does not affect the continuing existence of a national emergency, as recognised by the European Court in Martin United Kingdom 2001. Turning then to the rules that the applicant has disputed.
Counsel,
and these
just one question. How important is it to your case, if not your public relations in your country, that the interrogations reportedly did lead to information of another potentially larger attack to come?
Extremely important, Madam President. It shows that Rotania, first, was indeed facing an imminent peril, which induced it to use these methods, as my co-agent noted. What's the imminent peril? Of future terrorist attacks, Your Excellency, against, for example, in this case, at paragraph 38, an attack upon the Rotan National Day was planned.
So you characterize them as terrorists, the ILSA?
The respondent's submission does not turn upon these individuals being terrorists. We acknowledge that the definition of terrorist is hotly contested in international law. In regards, for example, to derogation or to the exercise of, or rather to necessity, the issue is the effect their actions have upon the state. So whether or not these individuals are international terrorists or internal dissidents, the fact that they were carrying out attacks against Rotanian religious property and Rotanian civilians means that they were creating this effect.
What is their status vis-a-vis international humanitarian law?
I'm sorry, I didn't quite hear
What
that
is the
question.
status of ILSA vis-a-vis international humanitarian law?
Your Excellency, that first of all assumes that there is an armed conflict, which both sides agree there is not. But if there was an armed conflict and the question of categorization emerged, we submit that these individuals are not a national liberation movement and therefore would come under only Article 3. For them to be a national liberation movement, the conditions are set out at Additional Protocol 1 of the Geneva Conventions. They must be either struggling against a racist regime, for example, apartheid in South Africa. They must be struggling against colonial occupation, colonial dominion, or alien occupation. Now, none of these three conditions are present in this case. The only one that could remotely come close would be a racist regime, yet it is noted in the compromise that Latvians face no active discrimination in Rotania and indeed are represented in the Rotanian Parliament.
But you're not suggesting, I trust, that if the interrogation, whatever adjectives one uses for it, led, for example, to information that ILSA had no plans for any future attacks whatsoever, that they'd changed their ways, would that have any effect on the violations, if any, of international law?
Madam President, we submit no. In relation to necessity, as pleaded by my co-agent, the issue is the grave and imminent peril at the time when the measures were carried out. In relation to my own submissions in regards to the admission of evidence derived from coercive interrogations, the fact that this evidence is buttressed by, at paragraph 38 of the compromise, a stockpile of flammable materials, indicates this evidence is reliable and has probative value.
Well, pardon me for interrupting, but this is something that concerns this bench quite a bit. Another element of necessity, as I'm sure you're aware, is that you would have to show that this was the only way that you could accomplish your goals or your ends, and we have heard from your opponents that there's substantial evidence in the public record about the effectiveness of interrogation, if you will, which goes to the reliability of what Ms. Penza said or didn't say about another imminent attack that, of course, didn't happen.
Madam President, the method the applicant suggests was of building a rapport with one's interrogation target. Now, in the present case, Rotania at the time was fearful of what Samara Penza called for, increasingly urgent measures to be carried out, which means that at the time, Rotania needed to implement more extreme measures that would get a far swifter result than building a rapport, particularly when the rapport to be created is between the Rotanian state and someone like Samara Penza, who is engaged in somewhat of a struggle against the Rotanian state. Rapport is unlikely in the present case. In regards to...
Sorry, to follow up the question put by the President, the difficulty I've got is what difference does it make to the legal position under international law that Ms. Penza made a confession or not?
In relation to necessity or in relation to the prosecution?
To necessity.
To necessity, Your Excellency, it makes no difference. For grave and imminent peril that urges these measures to be taken is assessed at the time the decision to use the measures was taken, which means that whatever the result of those interrogation methods might be, it has no bearing upon whether Rotania honestly and reasonably responded.
So can I ask you a related question? What was the purpose, what was the reason for abducting Ms. Penza?
From Adova, Your Excellency, to make sure that she was detained, unable to herself direct further attacks.
So it wasn't to interrogate her?
And that also, Your Excellency, would be part of it. As the ringleader of LAPS and ILSA, she would have information, which she did in fact have, about further attacks. If I might, however, turn to the fourth of Rotania's major submissions, that concerning Adova's attempt to prosecute Rotanian former officials. Now here, the question before this court is how to resolve two norms. On the one hand, the jus cogens status of the prohibition on torture, and on the other, the long-standing principle that one state may not sit in judgment upon another state by prosecuting its foreign officials in domestic courts. The applicant has contended that there is no relevant immunity in the present case, first, and second, that even if there is, the Pinochet case stands against the respondent and overrides this immunity. In regards to the first, as this court stated in the arrest warrant case, former heads of state, this is for President Kurgov, have immunity ratio in materia, functional immunity.
While you're dealing with immunity, if you look at page 40 of your pleading, you refer there to the fact that the exercise of jurisdiction by international courts over former heads of state is different to domestic. And you state there that state immunity for international crimes is expressly acknowledged in the Rome Statute, and you refer to Article 98.
Yes, Your
Now,
Excellency.
I have a problem in understanding the relevance of Article 98 at all in this context.
The points made in the respondent's written submissions there is that the jurisdiction of an international court is not affected by immunity, as an international court is not violating the sovereign equality of all states by passing judgment upon the conduct of one state. The reference to Article 98 refers to the original domestic exercise of jurisdiction under the Rome Statute by the holding state and sending that person before the International Court. So the two are distinguished. In Article 98 of the Rome Statute, it is stated that the obligation to exercise jurisdiction over, for example, war criminals, torturers, does not affect the obligation of states first to respect immunity. Now, the respondent's submission in relation to the immunity applying in the present case is that former President Kirgov has former head of state immunity and that Vinitsa has state immunity. It is the same functional immunity. It does not require Vinitsa to have been a head of state, but rather is afforded to all state officials for acts committed in official capacity.
Is torture a violation of international norms?
It is, Your Excellency. Yet the definition of official capacity does not require that the act itself be lawful. Indeed,
If it's a violation of international norms, what does the Congo case say about heads of state who violate international norms?
the separate opinion held that this immunity would no longer hold. That was 3 judges. The majority opinion of 10 judges held that there were only 4 exceptions to this immunity, and these are before an international court, for acts committed before taking up office, acts committed after leaving office, and for private acts. Now, the only way in which torture can come within these exceptions, as recognised by this court in an arrest warrant, is if torture is a private act. And I will address that now, if Your Excellency pleases.
Okay.
The applicant has relied upon the Pinochet case for this proposition. Yet, in 2007, the Pinochet case was revisited by the House of Lords in the Jones and Saudi Arabia case. In that later case, the House of Lords recognised that torture was committed as an official act. Indeed, the definition of torture in Article 1 is that it be carried out by public officials. So, as states can only act through their agents, and indeed the applicant is seeking to hold Rotania internationally responsible for acts committed by its agents, such as torture, it follows that if a state is liable under international law for torture, it is committed in official capacity, and that act is also an official capacity for the purpose of immunity. In the Jones and Saudi Arabia case concerning a civil claim for torture, the House of Lords distinguished Pinochet on the basis that the real rule of it was not that torture could not be an official act, but rather that the Torture Convention itself, by necessary implication, had overridden immunity for prosecutions. And it is our submission that even this narrower view of the effect of Pinochet is incorrect. In order for the Torture Convention to have overridden immunity, there must be no other way to reconcile its provisions with the customary rule of immunity. There is a presumption of no normative conflict to international law, as recognised, for example, by this court in oil platforms. And yet, the object and purpose of the Torture Convention and the provisions of it, for example, creating universal jurisdiction, Article 5, can be reconciled with immunity when there are instances of waiver. And indeed, in the Belhassan Ya'alon case before the US Court of Appeals, it was found that the Torture Victims Protection Act, which creates jurisdiction to claim for torture committed abroad, was consistent with the Foreign Sovereign Immunities Act, even though the latter act would only have operation when the state had waived immunity.
How would you like to respond to Article 2 of the Torture Convention that says no exceptional circumstances whatsoever and following related to torture exception to head of state immunity? What's your thoughts on that?
I know my time has expired. Might I answer your question?
Permission of the...
Yes,
Thank you.
please.
No exceptions to torture. Your Excellency,
And Article 2.
Yes.
It's no exceptional circumstances whatsoever.
Your Excellency, the respondent draws a distinction between what you refer to, which is the substantial prohibition on torture, and the issue before this court, which is the procedural bar of immunity from a foreign domestic court's jurisdiction. This is a distinction that this court recognised in the Rwanda and Congo case in 2006, where it held that a reservation to the Genocide Convention went only to enforcement measures and not the substantive prohibition on genocide. Accordingly, the jus cogens nature of torture does not conflict with the procedural customary rule of immunity.
Thank you.
May it please the court, this conclude the respondent's submissions.
Ms. Salmon, I have a question for you, and I apologize. I asked your opponent the question that I really meant to ask you, so I see why everyone looked blank. I just, frightfully, yes, we make mistakes, but the follow-up question, you'll understand why I confused myself. I want to clarify whether you are, what specific relief you are requesting on behalf of Rotania, vis-a-vis your two former officials.
Yes, Madam President. At paragraph 46, the respondent seeks a declaration of the unlawfulness of the applicant's conduct. This declaration, we submit, it would follow, would mean the quashing of the arrest warrant, as this court did in the arrest warrant case, and also the restitution, the return of Vinitsa to Adova, as this court also allowed in the town hostages case.
Thank you. Then my question that I have, and you will appreciate that it is something on the mind of everyone on this court these days. While we appreciate that under Article 59 of our statute, any decision is binding only on the parties to that case, there are things that we cannot really afford to ignore. So I want to know whether your government is prepared to give assurances that if we should order that Rotania, if we find that the abduction and the treatment and the prosecution of Ms. Penza and others was or is violative of international law, and order the repatriation and compensation that Adova requests, whether your government will take steps consistent with that order.
Madam President, I may make no undertaking or assurance in my capacity as agent. I can refer the court only to Article 4 of the Compromise, in which the parties have agreed to execute any judgment of this court in good faith.
Thank you.
May it please the court.
And my question to Mr. Leighton was the opposite of that, so perhaps you could address that very briefly. Your view, no, in the course of your final presentation, in terms of any assurances regarding the specific relief that they indirectly request.
He's not addressing it. It's more
Excuse me, Ms. Day. So twice I confuse you, I'm sorry.
That's totally fine. May it please the court? 3 points on rebuttal, but first to address your question, Your Excellency. Of course, we completely agree with our esteemed colleagues from the respondents that both parties will fulfill whatever this court decides in good faith. And in fact, if that were to not happen, the Security Council, under Article 96 of this court's charter, can, of course, enforce these rulings as well. Turning to the 3 points, most recently, respondents just cited Jones v. Saudi Arabia to say that the Pinochet decision no longer controls. But in fact, Jones v. Saudi Arabia did not overturn Pinochet because it was dealing with a current head of state, and it was a civil claim, quite different from the case we have here. Also, respondents claim that Adova has not met its burden of proof regarding torture, and respondents said that the crime of genocide case required that we prove beyond a reasonable doubt. In fact, however, paragraph 209 and 210 of the crime of genocide case outline that it's not a reasonable doubt standard, but rather this court is quite unique in that it chooses the standard of proof based on the crime alleged. Now, because this court has never heard a torture claim before, Adova submits this court should adopt the standard of proof that the Human Rights Committee does when looking at torture. That's the probability that torture occurred. The reason for this lower standard is, of course, the applicant alleging torture is never going to have all of the information because the alleged torturers are always reticent to give up that information. When we look to the case of Gilboa v. Uruguay, an aunt was the author of that case of a victim that she alleged was a victim of torture. All she said was that she alleged torture occurred. Uruguay did not respond. There was no further evidence, yet the court found that because Uruguay did not meet its burden to give some information, the court could find that there's torture even without further evidence.
Ms. Day, what was the burden of proof in the Bosnia and Serbia case? It was a very high burden that this court adopted
Absolutely,
in
it was.
respect of genocide.
Absolutely, it was, Your Excellency. In paragraph 209, it was clearly convincing. But as this court went on to show, that was for crimes of genocide or crimes of violation of state sovereignty. So, of course, respondents...
But why should torture be at such a low level?
Your Excellency, even if torture is in that clearly convincing level as well, what Adova submits is that both parties in this case would have some burden to bring evidence. In this case, Rotania did not let any Red Cross doctors into Camp Indigo, would not let any medical examiners actually find if there's information, and thus under the Corfu Channel holding, liberal findings of fact can be read against them. Your President was concerned with, although this is only binding on two parties, the ICJ, of course, does establish precedent in that the rest of the world is going to look to this outcome. If this court says that an applicant in torture needs to have beyond reasonable doubt or clearly convincing evidence, that would reward torturers that are really great at keeping things secret. And so in this case, Adova submits, I may briefly conclude, respectfully request this court decide in our favor today. Thank you.
Thank you, Ms. Day. Mr. Michael.
Your Excellencies, responding to the applicant's points in rebuttal, it was submitted that the burden of proof that was required was not beyond a reasonable, should not be beyond a reasonable doubt. Now, Your Excellencies, the cases which we pointed the court to before, namely the genocide case, held that the particular level or the particular burden that must be established depends upon the heinousness or seriousness of the particular allegations alleged against the state. And that is why there was a very high threshold in the crime of genocide, because it's such a serious crime. But so is torture, and therefore, similarly, a very high threshold should apply for torture. And that is exactly what the European Court of Human Rights held in the case of Shamayev in Georgia and Russia in 2002, and Angoliva in Bulgaria in 1997. And so the test is beyond reasonable doubt, and the applicant has not satisfied that burden. Additionally, may I note, Your Excellencies, that the rationale for a very high legal test for torture is that if the court were to accept lesser acts as somehow falling within this range of torture because of a lower burden, it would fundamentally weaken and dilute that prohibition on torture, because if such lesser acts were found to constitute torture, states would no longer respect that universal condemnation.
Mr. Michael, unless I misunderstand you, aren't you confusing two issues? One is what constitutes torture. The other is the burden of proving it.
That's correct, Your Excellency, but if acts are found to be torture which aren't established on the evidence, that will affect what is characterised under legal tests for torture in our submission. Your Excellency, it was noted that the Jones and Saudi Arabia case, or the Pinochet case as well, were against us. The ratio of Jones and Saudi Arabia was specifically that the Pinochet case, the real ratio behind that case was that there was an implied waiver into the Torture Convention, and that the Torture Convention required some sort of immunity to be waived because it would be ineffective. If I may finish that point.
Yes, please, sir.
But in our submission, it would not be rendered ineffective because states can always choose to actually waive immunity, and individuals can be tried before international criminal tribunals. May it please the Court.
Thank you. On behalf of the court, I just want to reassure all of the agents that while we asked a number of questions, which just reflects the importance of the many issues you are addressing today, the critical importance of the many issues you are addressing, we have, of course, studied all of your memorials carefully and will be studying them as we deliberate. Thank you. Please be seated. per tradition, we will, the judges will briefly introduce ourselves and given where we are in the rounds, brief comments on the presentations, and then announce the winning team and the best oralist. If I could ask my colleague, Judge Goldstone, to speak, please.
Well, thank you very much. This is, well, firstly, who I am and experience. My involvement with international criminal law, international humanitarian law, really began very suddenly in 1994 when I was unexpectedly appointed, and in some ways inappropriately appointed, as the chief prosecutor of the Yugoslavia Tribunal, the International Criminal Tribunal for the former Yugoslavia. It was a desperation move on behalf of the international community because they couldn't find somebody who was not vetoed by the Security Council. And President Mandela, who'd just been appointed as the first democratic leader of our country, was the flavor of the decade, if not the century, and they decided that if they could find somebody he supported, that it would go through the Security Council, and that's how I got into the Act. So it was a very steep learning curve, but I found that if one applies oneself sufficiently hard, and one can go up that steep learning curve. So that's how I became involved in international humanitarian law, and needless to say, I'm now teaching it. The other experience I had was on the South African Constitutional Court for 9 years after I left office in The Hague. This is my first involvement with the Jessup International Law Moot Court competition, and I couldn't be more impressed. I think just the magnitude of the whole endeavor, the number of countries, the number of teams, the unbelievable organization, the turnout here, and of course, above all and most important, the standard of both teams, and the 4 oralists we heard was extremely impressive. I must say, I was a judge for 23 years, and I wish that we had counsel as competent and as pleasant and as cooperative, and who know the law as well as they do. This was really a wonderful experience, and I admire the teams particularly for putting them through this grueling week of appearing for both sides and doing it again and again. So congratulations to all of you, and of course, congratulations to the other teams who've come here and are no doubt well represented in the audience. So it's certainly, speaking for myself, it was a great pleasure and a great privilege to be asked to be one of the judges.
David?
Well, I too want to say thank you for allowing me to be a part of this incredible months-long endeavor, and I was also incredibly impressed by all of the work that you had done. Like Richard, I never signed on to be a chief prosecutor. It just happens, and surprisingly so. The phone call I received, and I flippantly said, yeah, throw my hat in the ring, and walked back to my dinner, which was, I thought it was a credit card sale, and my wife said, who was that? And I told her who it was, and she laughed. She says, you'll never get that. And I said, I know, and we went down and finished our spaghetti dinner, and I promptly forgot about it until 6 months later. So, and there I was in Sierra Leone about 4 months after that. Of course, I was the chief prosecutor for the special court for Sierra Leone, and was one of the individuals who indicted Charles Taylor, the president of Liberia. So I had an interesting had an interest in head of state immunity. I wasn't going to go there. I have a vague familiarity with the concept and fully understand, but it was a privilege to, and I always learn something when I do these moots. I always learn a great deal as well. So, but I thought the teams that were representing you were smooth. They were very focused, and they certainly represent the best of the Jessup tradition. And I really liked your confidence. Confidence is very important when you advocate, and take that confidence with you when you join our profession, because that really carries a lot of weight. And of course, your knowledge of the law was first rate. So again, I compliment you and thank you for allowing me to be a small part of this.
And I am Lucy Reed, and no one's ever asked me to be a prosecutor. But maybe it's coming.
Would you like to? Would you like to be?
Well, if I can learn to ask as many questions with such determination, yes, I would. I think that this is a hard bench for the two finalists to have two such very esteemed and successful international prosecutors. I'm merely the president of the American Society of International Law. We hope not facing any liability for any advice I've given, or any questions I ask to the wrong side with dyslexia of countries. But as relevant here, though, I do sit on the Eritrea-Ethiopia Claims Commission, which is a sister body to the Eritrea-Ethiopia Boundary Commission. And what we have been doing on the Claims Commission, although we try to keep it something of a backwater, is decide civil liability for violations of the Geneva Conventions stemming from the war between Eritrea and Ethiopia. And I have a particular focus, because of that work, on the intersections and the overlay of international humanitarian law and international human rights law and Common Article 3, and how to work with those. And I try not to ask too many questions about that. And I've been involved in a number of ICJ cases when I was in the legal advisor's office at the State Department and in private practice. And I regularly do advocacy in front of international arbitral tribunals on public international law issues. And if I faced what you faced today, I would faint dead away, despite the experience. So I share the congratulations to you two as the finalist teams, and I won't repeat the comments that my fellow judges have made, except to say I'm fantastically impressed. I can't not say it with your knowledge of a huge body of complicated law. And I think it's a great investment of all the Jessup teams that you have learned all the law that Michael Scharf and others put into this complex problem. And also, of course, your ability to go back and forth from one side to the other. We know from, and I know from doing some earlier rounds, that of course the respondent's case is quite a bit harder in terms of coziness and warmth, and we take that into account as we judge the advocacy, and I'm sure you've heard this in every round. So with that, we have, well, I feel like going back to school. It's an A++ and an A+. The quality is so extraordinary that it was a very hard decision to make. But on balance, we have decided that in this case, let's make sure I don't get this wrong, that the applicants win. And as for Best Oralist, we are pleased to be able to announce that Ms. Day carries the day. Congratulations to all. I think we lose our jurisdiction now.
Awards, I am going to invite Tom Wilner from Sherman and Sterling up to say a few words. Tom is a partner at Sherman and Sterling's offices here in Washington, D.C. He's the head of the International Trade and Government Relations practice. And very interestingly, which is very relevant to many of you this year and the topic of the problem, Mr. Wilner has successfully represented 12 Kuwaitis before the United States Supreme Court who are being detained at Guantanamo Bay. So he's very much in line with Jessup thinking and of the Jessup crowd. So I'd like to invite him up and we'll present the awards to the teams.
Well, thank you. I want to say first just I'm glad you mentioned that. It was about 6 years ago, almost exactly 6 years ago, that we brought a case on behalf of the Kuwaitis in Guantanamo Bay asking for due process and the right to a fair hearing under habeas corpus. I consider a fair hearing the essence of the rule of law, and we're still fighting for that. That gives me a little credibility. I want to say how impressed I was with this whole process. I have not participated before, but I was so impressed with the problem, with the work that was done on it. I was so impressed also to see people, teams from all around the world. And I was amazed when I was judging to see how people could argue when English was not their native language. It was so impressive to me, and I congratulate you. I am actually... I have probably argued 100 times before high courts in the United States, and yet I am intimidated to be before you because you were just so great. I was also so impressed to see you standing up, defending legal principles, being from countries from around the world. And I don't know, Professor Scheffer, whether it's international law, but what you really are standing up in each country, in each place, you are points of light for the rule of law. I mean, law is the measure of civilization. It's its greatest protection and the most important thing. It protects an individual from being thrown in jail unnecessarily, arbitrarily. It protects businesses so they can do their business. It protects people from torture. And I was struck, I was very impressed by what Professor Scheffer said, and I think I would have said this anyway. But I think as you go out and lawyers in your communities, it's very important for you to remember not to be too technical in your arguments for the law so that you lose the purpose of the law. It's very important that you not become facilitators for violations of the law. You know, unfortunately today, we cannot take for granted, even in countries that call themselves the most civilized, that they will adhere to the rule of law. Judge Goldstone made a point today, and I was impressed by it, that I don't care how you really define torture. If you're hanging somebody by the wrists, it's pretty darn medieval and wrong. And I think you've got to keep that in mind. So, I was most impressed, the lawyers I was most impressed with, aside from those in the room, over the last year were those lawyers in Pakistan who you saw in the pictures in the newspapers in their suits and their ties protesting against the violation of the rule of law, throwing the Supreme Court into jail or taking them from office. Those guys in Pakistan represented the best of lawyers, I think, and their best work was not really in the courtroom, although I'm sure they do that well. It was going out and protesting when the rule of law was threatened. So I encourage you all to go out in life, be great lawyers, and argue well. But remember, always stand up for the rule of law. You are guardians of the rule of law, and that's your greatest obligation. So.
So to present the awards, I will start with second place and announce the name of the university and the country for the first time in the public. The second place award goes to Team 522, the University of New South Wales from Australia. We'll do Best Oralist now. The winner of the Best Oralist Award and the Sherman and Sterling World Championship Cup round is the agent from Team 211, Margot Day. And the world champions of the 2008 Jessup competition are Team 211 from Case Western Reserve School of Law in the United States.
Congratulations.
And I think we should also all stand and offer a round of applause to the judges and to all the judges.